Good morning. It is 10 a.m. Tuesday, January 14th. I'd like to call to order the board meeting for the Tennessee Board of Funeral Directors and Embalmers. As we begin our meeting, I'd like to bring to your attention there's a sign-in sheet on the table by the door, and if anyone would like to make comments about an agenda item, please indicate so by your name as you sign in. Public comments will be accepted near the end of our board meeting, and I'd like to welcome and thank the visitors that we have today. Ms. Bohannon, would you please call the roll?
Don Haynes,
Here.
Chris Lee,
Here.
Randy Nash, Wendell Naylor,
Here.
Scotty Porsche, Pam Stevens, Tim Willer.
Here.
Mr. President, we have a quorum.
Thank you, ma'am. First on the agenda today is a recommendation that we adopt today's agenda for the meeting.
So move. Second.
Mr. Wheeler with the motion and Mr. Haynes with the second. All in favor, please respond by saying aye.
Aye.
Next on the agenda is the approval of the meeting minutes for November 12th, 2024. And I believe everyone's received that in their packets. I'll open the floor for a motion.
Motion to approve.
Motion to approve by Mr. Haynes, second by Mr. Wheeler. All those in favor, please respond by saying aye. Aye. Next on the agenda will be the legal report by Mr. Bryant. What I'd like to do, gentlemen, is after each case is read, I'd like to open the floor for comments or suggestions. Once that is completed or there are none, I'll call for a motion, and I think we can move through these at a pretty good pace. Mr. Bryant?
Good morning, board members. The first complaint is complaint number 2024-051-451. This case was administratively opened following a routine inspection conducted on September 11th, 2024. During the course of this routine inspection, the inspector observed the following. Respondent had employees on their website that were not properly identified as to their licensing status. Specifically, the employees were not notated to indicate whether they were a licensed funeral director or embalmer or a non-licensed employee. The inspector stated that they had previously spoken to the manager of respondent establishment concerning this violation on previous visits, but that the corrections had not been made. Respondent replied stating that the violations were corrected on the same day as the inspection. Respondent stated the employee titles were erroneously listed on the website, and that following notice of the violation, they contacted the company that ran their website to make the necessary corrections. Based on the above, we would recommend a letter of warning.
Any questions or comments? I've got one, just Mr. Bryant, that I read back. It said the inspector stated that they had previously spoken to the manager of the establishment concerning the violation on previous visits, but it had not been corrected until, I guess, the September 11th visit.
That's correct from my understanding. I think kind of typically when we send the inspectors out there, if they catch something like that, something too that may be a little, I won't say ambiguous because it's in the laws, it's in the rules, and it's the responsibility of the respondent to know those and abide by those. But something like that, they'll usually say, hey, we noticed this, that would be a violation, please take care of that. And when they come back, they kind of make a note to double check on this, did that get taken care of? I'm not sure how many times that was brought up in the past, whether that was a one-time thing or a multiple-time thing, I'm not entirely sure, but it had been noted in the file whenever this was in the inspection report that it had been mentioned at least once before.
Thank you, Mr. Bryant. And I did notice that this establishment has zero history. I'll open the floor for a motion on this case.
I make the motion we approve council's recommendation.
Second.
Have a motion by Mr. Wheeler and a second by Mr. Naylor to accept the letter of warning. All in favor, please respond by saying aye. Aye. All opposed? Motion carries. I think I can hear everybody approved, so Mr. Bryant, number 2.
Next complaint is complaint number 2024-051-601. Complainant alleged that an employee of respondent funeral establishment had stalked himself and his girlfriend while, quote, a deceased body had been abandoned in the respondent's chapel van, end quote. Complainant stated that the employee was ultimately arrested and alleged that respondent permitted the employee to return to work, who again stalked complainant, returned to work, and was arrested a second time. Complainant contended that respondent negligently permitted the employee to return to work after allegedly abandoning a decedent in their chapel van. Further, complainant contends that respondent violated applicable laws and rules by failing to notify the board of the employee's arrest. Respondent replied stating that, to their understanding, this matter involved an alleged love triangle between the former employee, complainant, and complainant's girlfriend. The manager of respondent's establishment stated that they were out of the country on the dates that this incident occurred, but when they were called and made aware, they instructed staff that the employee was not allowed to come to work and that their employment would be terminated. The respondent stated that from their understanding, the employee was incarcerated from August 11th through 19th, 2024, and upon being released and attempting to return to work on August 19th, 2024, was terminated. Respondent stated that they are unaware of any obligation on behalf of respondent establishment to notify the board of an employee's legal incident. Based on the above, legal believes the rule complainant is attempting to reference is 0660-01-.031, section I, which states, in addition to any other requirement of the board's rules or any statute pertaining to the profession of funeral directing or embalming, the following shall be reported in writing to the board by the licensee within 10 days of the effective date of the change: a conviction of a misdemeanor involving fraud, dishonesty, or moral turpitude, or a conviction of any felony. The obligation is on behalf of the licensee, and in this case, the employee, not respondent establishment. A complaint has been opened against the employee's funeral director and embalmer's license, and that matter is currently under investigation. But based on the information provided by complainant, there is no proof that respondent establishment has violated any applicable laws or rules. Therefore, we would recommend closure.
Any comments or questions? If not, I'll ask for a motion on the case.
Motion to accept council's report.
Have a motion by Mr. Haynes, a second by Mr. Naylor for closure. All in favor, please respond by saying aye. Aye. All opposed? Motion carried. Number 3.
Number 3 is complaint number 2024-052541. Complainant, writing on behalf of the brother of the decedent, alleged that respondent had conspired with a member of his family to exclude him from the planning of his sister's services. Complainant contended that their father, the brother of the decedent, was the next of kin, and alleged that respondent had ignored his communications to obtain a death certificate for estate planning. Complainant also expressed grievances that the visitation was canceled, and when asked why the other family member had been permitted to make that decision, was told that a brother did not take precedent over a child of the decedent. Complainant then alleges that the individual respondent had identified as the child of the decedent was in fact not a child of the decedent, but was, quote, simply the mother of her grandchildren, end quote. Respondent replied through counsel stating that the decedent died leaving a sole surviving child, and that this child made payment for the funeral services, participated in the planning of the services, and made decisions regarding the visitation. Respondent stated that they honored those choices as required to do by law. Respondent also provided an obituary that identified that the decedent had a daughter-in-law, which complainant had referenced, but also had a daughter, who respondent had designated as next of kin and made funeral arrangements with. Based on the above, complainant contends that the decedent's brother should have been named next of kin, and state that the respondent chose to acknowledge a daughter-in-law over the decedent's brother. However, respondent provided proof that the next of kin determinant was a daughter of the decedent, and that they followed her wishes in compliance with the law. Based on the above, we would recommend closure.
Any questions or discussion? I'll open the floor for a motion.
I make the motion we accept council's recommendation.
Have a motion by Mr. Wheeler, a second by Mr. Naylor to accept council's recommendation of closure. All in favor respond by saying aye. Aye. Any opposed? Motion carried. Number 4.
Number 4 is complaint number 2024-053261. This case was administratively opened following a routine inspection conducted on September 17, 2024. During the course of this routine inspection, the inspector observed the following. Respondent's establishment license expired on June 30th, 2024. Respondent did not meet the requirement for reinstatement and renewal until September 2nd, 2024. During this unlicensed period, respondent remained open for business and had written 21 funeral contracts. The owner and operator of Respondent replied stating that when he and his wife had renewed their funeral director's licenses in June, they thought they had also renewed the establishment license as well. Respondent stated that it was not until they received a call from the licensing office on September 3rd, 2024, that they realized the license was expired. Respondent stated it was never their intent to operate without an establishment license. Based on the above, we'd recommend a $2,000 civil penalty, authorized via consent order, and a formal hearing if necessary.
Questions or discussion?
During this time period, did the establishment issue any pre-need paid contracts? Because I take it the 21 you're talking about were at need.
That's my understanding. I'm not entirely certain if this establishment is registered with our department as a pre-need seller. I imagine if a good portion of those 21 contracts were pre-need, one would have also been open on the pre-need side as well. To my knowledge, there was not another complaint open on the pre-need side. So I would, without knowing 100% for sure, I would say most likely those 21 were at need.
I was just wanting to make sure that we're on at need because it's hard, I guess it's hard for me to realize an establishment doesn't have a pre-need license since that is a big part of our business. So that was my big question was any pre-need contracts issued, during that period of time?
No other questions or comments? I'll open the floor for the motion.
I make the motion, we accept council's recommendation.
Second.
Have a motion by Mr. Wheeler, a second by Mr. Naylor to accept council's recommendation. All in favor, please respond by saying aye. Aye. Any opposed? Motion carried. Number 5.
Number 5 is 20240533951. This case was administratively opened following a routine inspection conducted on September 18th, 2024. During the course of this routine inspection, the inspector observed the following. An employee of respondent establishment had allowed their funeral director's license and embalmer's licenses to expire on June 30th, 2024, and did not meet the requirements for reinstatement until July 15th, 2024. During this unlicensed period, the employee continued to be employed by respondent, signed off on 2 contracts, and continued to wait on families. Respondent admitted that the employee had a lapse in their license and that they believed he had renewed his license on time. Respondent stated the employee had problems submitting online payment and that he was not very web savvy. Respondent stated another employee had to assist him in setting up a password and making payment. Respondent stated this unknowingly caused a lapse in his license as they believed it had been submitted on time. Respondent further stated that the employee did wait on 2 families during this time, but did not embalm, and that the license is now renewed and active. Based on the above, we'd recommend a $500 civil penalty, authorized via consent order, and a formal hearing if necessary.
Questions or comments? I've got, I guess, one. We have been, or tried our best to be very consistent with our fines on these expired licenses, and they seem to be coming to us more and more every month. And I've also noticed that funeral establishments are getting the fine, and then usually the companion case involves the funeral director itself, and they usually have a letter of warning. I'll open the floor for any discussion. Part of me understands the funeral establishment needs to make sure that their folks maintain their licenses, but these are grown men and women that have the responsibility of renewing their license. So I'm thinking, a higher penalty may start getting attention, or dividing the penalty between the funeral establishment and or the funeral director. Any comments on that?
What's the penalty for renewing an expired license, a fee? Like, is it $100?
The fee or the renewal amount?
Just the penalty for renewing after the license
We
had
have
expired.
usually, first offense, around $250 has been our standard. And as you can see, it seems more and more is coming before us. So I don't know the solution.
I think what Mr. Haynes is referring to, Mr. Gerbil, when someone lets their license lapse and then they renew it, what is the penalty the state puts on them?
That's a $200 late fee for the renewal itself. Goes to the individual, and then what the board assesses is when they practice with an expired license, and if they don't practice, then there's not a complaint opened against them. They just pay the late fee, and that's the end of it. But when they continue to practice with an expired license, then the complaint is opened. That's where the field rep's been out, done the inspection, and has a certain number of cases that this person has done while their license was expired. And that's when the board assesses a civil penalty in those situations.
I agree with Mr. Lee that. Oh, okay. I agree with Mr. Lee that I think a higher penalty is warranted. Maybe that will help persuade people not to let their license expire, and it might also help the deficit with the board.
I agree completely with Mr. Haynes and Mr. Lee. It seems like 50% of what we hear now is expired license, and it seems like we've about heard every excuse possible. This one says he's not tech savvy, he, she, whatever. But at the same time, the staff here is available for emails. You can email. And if you're having problems getting on and paying your fees, I think the staff's more than willing to walk you through it or do it. So I agree completely with Mr. Lee. I think this is just becoming such a common occurrence that it's sort of like the speeding ticket. I just pay it and we'll move on. You get your next ticket, it's the same price, and you just keep doing it and doing it. So I think maybe the board needs to look at maybe becoming a little bit stiffer with their penalties, and maybe that will get these licensees' attention a little bit.
And just to add that to that as well, kind of, I know since we see so many of these, every single legal report have mentioned before that, and it seems like you all are not struggling with it, so this is a good thing, but I'm just putting this out there if anyone has any reservations on that. While the board can't always set precedent with what we've done, I never want the board to feel like they're shackled by precedent based on when things change or things become kind of a recurring problem. I think maybe the October or September meeting, I mentioned that, if the board decides that this is recurring enough that the penalties do need to come up, then that's totally permissible, especially since the quantity of complaints we've seen involving this issue. So you all were on that path anyway, but just wanted to say if there are any hesitations or reservations about that, you're never completely shackled by precedent of the board so long as, there's some, I guess, reason or justification for diverting from that.
Well, Mr. Lee, it's time for us to raise this now.
Before we do that motion, the second part of my discussion is these always have a companion case. This is the establishment, and the next one's going to be the actual funeral director itself. Or do we need to look at the establishment and the director, or just raise the penalty on the establishment and go with what's recommended on the funeral director?
Well, the funeral director is going to be paying a fine anyway. Is that not correct? $200?
That's correct. If they're late, they pay just a flat $200 late fee for that. So since that license has been renewed, that $200 from the licensee has already been paid. Correct. And I guess the logic and why I've recommended that in the past, where the establishment gets the penalty and the individual gets the letter of warning, is twofold. One, usually I would say 9 times out of 10, we get an individual have no disciplinary history whatsoever, and kind of for that first offense of it's bad that they let the license expire, but it is encouraging at least that it's not a recurring problem where every time they're up for renewal, they fail to do so. And usually the establishment has some level of disciplinary history, even if it's not directly related. I mean, this establishment in particular, their most recent was 2017, but they do have 4 past cases where there was some form of discipline issued. So that's usually why it's a little higher. The other reason for that is essentially for the reason stated, that with no disciplinary history, the individual has already paid a $200 late fee. This letter of warning keeps that in our record, that if this does become a recurring issue, future iterations of the board will know that, and we can assess at that point. Likewise, from the establishment perspective, as was mentioned by Mr. Lee, there is some level of accountability there that your employees are, licensed and those things are checked on. So that's the reason, I guess, the logic behind why I've structured those recommendations in that way. But of course, as always, if the board feels that it'd be more appropriate to change that, do something different, certainly within your power.
So we still with, because when we look at the funeral director, he did sign off on 2 contracts. And, it's our job to protect the consumer. And so with him signing off on 2 contracts, he was not licensed.
I understand that totally, Mr. Whaler, and I agree with that. So if there's no other comments or questions on the establishment on number 5, I'll open the floor for a motion on that, and then we'll go to the funeral director itself.
I'd like to make a motion that we increase the civil penalty to $750, replacing the $500 that council recommended.
Have a motion on the floor to increase the penalty from 500 to 750. Is there a second on the motion?
Second.
And a second by Mr. Naylor. All in favor, please respond by saying aye. Aye. Any opposed? Motion carried. Number 6, Mr. Bryant.
Number 6 is complaint number 2024-053971. This case was administratively open following a routine inspection conducted on September 18, 2024. During the course of this routine inspection, the inspector observed the following. Respondent in this case is the employee from complaint number 5 who permitted their funeral directors and embalmers licenses to expire on June 30th, 2024, and did not reinstate until July 15th, 2024. During the unlicensed period, respondent signed off on 2 contracts and continued to wait on families. And again, respondent's reply was identical from the preceding complaint.
Questions or comments? I'll entertain a motion for council's recommendation or changing that to a fine.
Mr. President, I think we need to change this to a fine because he did see 2 families, and it says he continued to wait on families. So if nothing else, a $250 fine.
Second.
Have a motion on the floor for the recommendation be a $250 fine, and a second by Mr. Haynes. And I agree in that this case, he has no prior history. I think a $250 fine plus the penalty that he's going to have to pay may make things better down the road. All in favor, please respond by saying aye. Aye. Any opposed? Motion carried.
Next complaint is complaint number 2024-053981. This case was administratively opened following a routine inspection conducted on September 23rd, 2024. During the course of this routine inspection, the inspector observed the following. The manager of respondent establishment had allowed their funeral director's license and their embalmer's licenses to expire on June 30th, 2024, and did not meet the requirements to reinstate the license until July 22nd, 2024. During the unlicensed period, a respondent had written 2 funeral contracts without a valid manager. Respondent stated that the lapse in licensure was unintentional and that the license was ultimately renewed once they were made aware it had expired. Based on the above, we'd recommend a $250 civil penalty, authorized via consent order, and formal hearing if necessary. Though also realizing that based on the previous complaint, that one will likely be changed, which is totally fine. I would, based in light of the board's decision on number 5, I would actually recommend that the penalty, just to remain consistent, be higher than $250.
Discussion or questions?
I agree completely with counsel and with stating he did 2 funeral contracts without a valid manager. I think each violation warrants a $250 fine, so I would like to increase that to a $500 penalty.
Have a motion on the floor by Mr. Wheeler to increase the civil penalty to $500. There a second?
Second.
Second by Mr. Naylor. Everyone approve the motion, please respond by saying aye.
Aye.
Aye. Any opposed? Motion carried.
Next complaint is complaint number 2024-053991. This case was administratively opened following a routine inspection conducted on September 23rd, 2024. During the course of this routine inspection, the inspector observed the following. Respondent is the manager from complaint number 7 who had allowed their funeral directors and embalmers licenses to expire on June 30th, 2024 and did not meet the requirements to reinstate until July 22nd, 2024. During the unlicensed period, respondent had written 2 funeral contracts without a valid manager. And again, respondent reiterated their reply from the preceding complaint, stating that the lapse was unintentional and it is renewed as soon as he was aware of the expiration. The written recommendation is a letter of warning, but again, for consistency's sake, I would recommend that be moved to a civil penalty.
Thank you, Mr. Bryant. Any questions or discussion?
Again, I agree with counsel, and I would like to make the motion that we do a $500 penalty. Again, $250 for each offense, and since there was 2 offenses.
Have a motion on the floor by Mr. Wheeler, the recommendation of a $500 civil penalty. Do I have a second?
Second.
Second by Mr. Naylor. All in favor of the motion, respond by saying aye. Aye. Any opposed? Motion carried. Number 9.
Next complaint is complaint number 2024-057471. Complainant stated that on October 22nd, 2021, she, her husband, and mother-in-law went to respondent funeral home to set up a pre-need contract for cremation services. Complainant stated that her mother set up transfer of the insurance to pay for part of the cost. Complainant stated at the time they received a statement of funeral goods and services that was not itemized except to indicate a direct cremation for $2,295, alternative container for $100, death certificates for $30, and sale tax for $9.70, with costs totaling to $2,434.70. Complainant stated the insurance was assigned at that time and stated they were aware the insurance would not cover everything and that they would need to accrue another $400 or so to cover the difference. Complainant alleged that when they tried to prepay the difference, respondent did not allow them to, as they stated they would need to rewrite the contract. Complainant stated their mother died on September 6, 2024, and that when they arrived at respondent establishment, they were given another contract with a total cost of $2,837.19. Complainant stated that respondent informed them that the cost of cremation had gone up. Respondent replied, stating that according to their paperwork from the October 22, 2021 meeting, the decedent had wanted to irrevocably assign the amount of the funeral expenses to respondent establishment. Respondent stated that the written goods and services were for the price of the direct cremation, 2 death certificates, and that they had made an unfunded pre-need arrangement in which prices were not guaranteed. Respondent explains that when a family irrevocably assigns the proceeds to the funeral home, this does not guarantee pricing or lock in a specific price, and that this is only done when a life insurance policy is written by their funeral home and placed in an insurance trust. Respondent stated that complainant was not allowed to prepay the difference because the insurance company they write their pre-need funerals with only permits them to write a policy for $500 increments, and that the amount was less than $500, and that the denial had nothing to do with needing to rewrite a contract, because a contract had never been written. Respondent also stated that he cannot legally accept a prepayment for a funeral without applying it to a funeral, and that in this case, a death had not yet occurred. Finally, respondent stated that when the family came in September of 2024, they provided a purchase contract reflecting the services quoted in October 2021, but with 2024 pricing. Respondent provided a copy of the Statement of Funeral Goods and Services dated September 6, 2024, which is itemized to reflect the cost of the direct cremation, death certificates, and an alternative container. From legal's review, it appears that the complainant's mother and complainant were given a Statement of Funeral Goods and Services when the insurance funds were assigned to respondent establishment in 2021. complainant operated with the belief that the prices from 2021 have been locked in since the insurance funds had been assigned to respondent establishment. The increase in price that complainant experienced came from the increase in pricing from 2021 to 2024. However, the 2021 Statement of Funeral Goods and Services was not a binding contract because it was not signed by either party. Included in the document was an itemized price for direct cremation at $2,295, an alternative container at $100, death certificates at $30, and sales tax for $9.70. Although respondents stated, quote, the copy of the Statement of Funeral Goods and Services provided an estimate, not a guaranteed Statement of Funeral Goods and Services, we made an unfunded pre-need arrangement in which the prices are not guaranteed, end quote. Respondent put the $2,295 number representing the direct cremation and put the $2,395 number representing direct cremation in the alternative container in boxes marked on the contract as, quote, total services guaranteed and total cost of selected items guaranteed, respectively. Likewise, respondent provided the information of their funeral home, their address, and phone number in the signature box of the contract, foregoing only their signature marking official agreement and acceptance. Complainant signature box did not have any information provided. Based on legal's review, although this document may have been used to show the family what the cost would look like generally speaking and was an, quote, estimate, not a guaranteed Statement of Funeral Goods and Services, end quote, and the arrangement may have been, quote, an unfunded pre-need arrangement in which the prices are not guaranteed, end quote. Based on the document and the guaranteed notation next to some of the prices, it would be reasonable for the reasonable person to leave that arrangement conference, believing that the prices they had been given were locked in. Arguably, this may be considered a violation of professional conduct for leading complainant and their family to believe, whether advertent or inadvertent, that the $2,434.70 price that had been quoted in October of 2021 was a guaranteed price that had been locked in upon the death of the decedent in September of 2024. So based on all of that above, we would recommend a letter of warning focused specifically upon respondent's obligation to educate the consumer about guaranteed and non-guaranteed pricing, and likewise focus on the risk of using official statements of funeral goods and services documentation to make estimations regarding pricing and future pricing.
Any questions or comments? And I'll start if that's okay. I agree with the recommendation that the funeral home did not legally violate anything, but it's our job, I think, to make sure the public, it's easy for us to sit up here, we write contracts all day, but I think, and I don't know the big difference, but a letter of warning, I would like to change that. I won't make a motion yet, to maybe a letter of instruction specifically telling them what to do and how to handle this in the future so the public understands exactly, what they came in and the difference between funded and non-funded. So I'll kind of leave that at that for now and see what anyone else has to say about it.
So there lies my big question. We've got something that states it's guaranteed. To the normal consumer, when you walk in, if you give them something that's guaranteed, whether signed or not, they left believing they had secured this price. So I'm having some problems believing the funeral home misrepresented to their consumer what they should have done. They should have, written on the top or something that it's an unpaid, unfunded pre-need or whatever, and that these prices are subject to change. And I didn't see any of that. And usually when I have a family come in, if they sit down and want to do pricing with me, I do the whole thing. I sign it, they sign it, but I mark it that it's unfunded and these are prices subject to change. So I feel the funeral home has misled their consumer. And I have some huge issues with that.
Right. I think this was a tricky one because, so this one was actually filed with the Consumer Protection Division at the AG's office. And then those are always a little tricky because there's always a delay. When they realize internally it's probably better suited here, it gets referred to us. And I don't know their upload system of being able to, I know they can upload documentation. So all that to say, all we got from complainant was basically a paragraph explaining this, and all the documentation provided came from respondent's reply. So it is tricky, I think, and I guess that was referenced in the language of, I don't know if the failure to inform the consumer was intentional or non-intentional. It's tricky to know, since I guess we're talking about a conversation that occurred in September or October of 2021, without complainants supplying any documentation to show anything to that level. I think looking at it and parsing through the documents, what became clear is that they were using that statement of funeral goods and services as, here's what the math looks like. We've got direct cremation here. Let me write a number in. This is what we're looking at, generally speaking. Here's an estimation of prices. I think where I won't say what went wrong, but the attorney in me would say, don't do that in the future, is write a number in the guaranteed box where, again, that family who may not be very familiar with the funeral industry walks away with that piece of paper thinking, this is the price, this is it. So I certainly agree that that's what we're talking about, is that violation of professional conduct to give them that number in that guaranteed box and not explain that this is a general estimate. And again, we don't know to what effect they did explain that in that October 2021 meeting. Evidently, what they explained, if anything, didn't take with the consumer, which is unfortunate in this circumstance. But so I guess that was the logic behind the recommendation of the letter of warning, of trying to toe that line of, I do think there is an obligation owed to the consumer of explaining that, because it can, as I have learned while in this program, it can get very nuanced and confusing pretty quickly. But not knowing specifically what may or may not have been disclosed in that conversation back in October of 2021, that's why I was erring on the side of a letter of warning, of to kind of toe that line, and hopefully that be enough to say, hey, whenever families come in, you need to make it abundantly clear what's guaranteed, what is not, what is an estimation. So long-winded way to explain the logic on that, but I agree. We're all on the same page of talking about the same problem for sure. I would say if it gets referred, barring something that's outside of our jurisdiction, 99 out of 100 times they probably just close it and defer it to us. If it pings a couple of other things, they may do something on their end, or it may go to a couple of different places. But I think usually when it's this specialized, it's probably just closed with them and then comes to us.
So I guess I go back to like what Mr. Naylor said earlier. We are the people that are supposed to educate. So if a family walks in and they leave, just like if I go buy a set of tires, or I get a price on tires and they give me $1,200 for 4 tires and it says guaranteed, and I go back and then they tell me it's $1,600 and something, I'm going after them because they gave me a guaranteed price. And I guess that's where I'm having problems, is where it, stated total service is guaranteed. If I'm a consumer, I'm walking out figuring I have got the price I needed, and it shouldn't go up. That, and there again, they should have written somewhere on that statement of goods and services, these prices are good for 30 days, or they're subject to go up, or whatever. I'm not seeing that, and I might, it might have not been on there. It might have been on there and just overlooked. And there's where I'm having some problems, that the consumer was misled.
Right, and I totally understand that, and I agree. From what I'm seeing on the documentation, there's nothing written that states that this is just an estimate, this is not final pricing, anything like that. I guess the argument on the flip side would be is that, so looking at the documentation, we have the itemization, which I went through before, just normal, pretty straightforward statement of funeral goods and services. And the respondent provides their information. So they provide their name, their address, and their number. They do not sign the agreement, and then there is no agreement and information signed by the complainant or their family. So I guess it's tricky too in getting into. So in law school, we talk about the reasonable person. What does the reasonable person believe? And I see 2 different flavors here. If I see a reasonable person walking in, leaving with that piece of paper, having a number written in the guaranteed number box, and thinking that's it. I'd also see a reasonable person say, well, I never signed anything, so I should know that that price isn't locked in. It's tricky because I know the funeral service is one that can be a little niche and confusing, and you're going through a lot also all at the same time. So again, that was, I think, my logic of a letter of warning, in that you do have a responsibility to the consumer to explain those things, and understanding you may have verbally. You didn't write anything down, which maybe you should have, and maybe you had that conversation with them. But good, bad, right, wrong, that family left evidently, or at least came back 3 years later thinking that it had been locked in. And if it was explained, it maybe needed to be explained a little bit better. And if it wasn't explained, it probably should have been explained. But again, I also see from the reasonable person perspective that, a price being locked in is tricky to argue whenever you haven't signed a contract for it. So I guess kind of the lawyer law school reasonable person brain is kind of pulling me in two different directions. And unfortunately, that's the problem. I leave you all to parse through and figure out.
Any other
But
questions?
the letter of instruction will give them what we really want them to do going forward.
Correct. And Mr. Gribble and I had discussed this before, and I know we've done letters of warning and letters of instruction in the past, and anticipated that this one would be worded in such a way to be very clear and very direct. Planned on using probably, I won't say strongest language, but most direct language of a letter I've written since I've been here to make it abundantly clear that this is on thin ice.
I make a, yeah,
Go ahead. No, I was going to ask for.
yeah, I make a motion that we change the recommendation from a letter of warning to a letter of instruction.
Second.
Have a motion on the floor by Mr. Naylor, a second by Mr. Haynes, to change the recommendation to a letter of instruction. All in favor, please respond by saying aye. Aye. Any opposed? Motion carried. Number 10.
Number 10 is complaint number 2024-057081. This case was administratively opened following a routine inspection conducted on October 16th, 2024. During the course of this routine inspection, the inspector observed the following. An employee of respondent establishment had allowed their funeral director's license to expire on July 31st, 2024, and was not reinstated until September 24th, 2024. During the unlicensed period, the employee made funeral arrangements for one decedent. Respondent stated that during the employee's time with them, the employee had a, quote, strong commitment to professionalism and compliance, end quote, and that they were not informed nor aware that the employee's lapse in licensure. Respondent stated that this was the first instance of any licensing issues since the employee had began working there, and that they had no reason to believe she would fail to renew her license as it had not been an issue in the past. Respondents stated that they will ensure that their staff operates within all regulatory guidelines in the future. Based on the above, the written recommendation was a $250 civil penalty to authorize the consent order in a formal hearing if necessary, though understanding the board may choose to change that given the earlier complaints.
One question from me, Mr. Bryant. Does this one not have a companion funeral director case?
It does, yes. This is it is the very next complaint, but I'm realizing in the write-up I failed to make that clear. I didn't put the language that this is with the preceding complaint. So complaint number 11 is the companion complaint with the individual. I see where it's listed as funeral establishment.
So number 11 should be director.
Correct, yes.
Real quick, I think just for information, I'd like Mr. Gribble, if you would, tell us what the steps are when someone's license is coming, just for the record. Since we're dealing with this so much, I'd like to get it on record so that people know these are the steps the state does, and this is how it works.
Okay, all funeral director, embalmer, and funeral establishment license expire the last day of the month. So let's say a license expires February the 20, I'm going to assume, I haven't looked at the calendar. I don't know if this year has 28 or 29 days in it. But let's say it has 28 days in it. Then on January the 2nd, which is almost 60 days ahead of time, especially if the month has 30 or 31 days in it, there's a notice that goes out to them. It's either emailed or sent to them in the mail, depending on how they've elected to receive their notifications. And they have that in addition to obviously being their responsibility to know to keep up within when their license expires. And then if that doesn't, if it's a funeral director and embalmer, we don't contact them anymore. However, if it's in a funeral establishment, our staff makes a phone call to every funeral establishment prior to the end of the month that their license expires to notify them, that, hey, you got an establishment license that expires the end of this month. You haven't tried to do that 7 days. Miss Bohannon takes care of it and getting the staff to do it, but typically about 7 days ahead of time. So then if they don't renew, then it goes to an expired grace status, and they have 90 days to reinstate that or to meet the requirements to reinstate it. They get a letter. She sends, we make sure those are sent out too, usually in the first week after the license expires, first week or 10 days. There's a letter that actually typically emailed to them and then mailed to them so that catch them one way or the other to make sure that they get it. And they have 90 days then to reinstate that. During that 90 days from the date of the expiration, then they pay a $200 late fee on each license, plus continuing education requirements or whatever else they must do to reinstate that. And then when they pay it, then they get their license, and it's reactivated again in an active status.
So what I'm hearing is the state does their due diligence. They follow through. So all these that are expiring, it solely lies upon the funeral establishment and that licensee. It's their fault, period. And technically, after we continue to see so many, their excuses are about as unacceptable as they possibly can be, because it appears the state has done due diligence through its staff and all. And there's no excuse to me to have an expired license. I just wanted that on the record. New year, it's out there for those people.
I think, too, to add to that, the three kind of, I guess, most common flavor excuses that we see is that it goes to an old email or an old address or something to that effect. And I understand that. Also, for BPR, for my personal professional licensing, I have that linked to 3 different emails, one of which is only exist for purposes of that email in case it doesn't come through elsewhere. I understand it can go to a junk folder. In most mails, you can right-click it and click, hey, don't count this as spam. So there are mitigations you can do on that front to make sure it gets to where it needs to go. And it's just, you can't be too cautious of having it being sent multiple places. So any licensees who may be listening on that front, just, it's way better to be overcautious than it is to risk that. 2 is, Core does a lot of things very well. Murphy's Law says if you wait till the very last day, Core will inevitably be down for maintenance. Don't wait until the very last day, because that system, something can happen that can cause delays. And we understand that you're trying, and it may not have been your fault it didn't get done that day, but you also have a long length of time to get it taken care of. And then lastly, we do know that there was a law change with the continuing education a few years ago regarding what's regarded as in-person, needing an X amount of in-person. We have seen some people say that I'm having trouble getting those in time. And I would just encourage also any licensee listening on that front as well to be proactive and get those things taken care of. When you're able to, you have a good period of time to accrue that continuing education. And because of that additional, I guess, requirement in the continuing education hours, that it was all licensees were made aware of that. So just would encourage that. I know kind of around the holidays, there's a lapse and when those are available to be received and taken. And so we just encourage people to be proactive of getting those as well. So you don't find yourself in a spot, my license expires in 2 weeks. I still need 5 hours of in-person hours and I don't have a way to get it. So just be proactive.
No more questions or comments. On number 10, we have a recommendation for a $250 civil penalty. I'll open the floor for motion.
I would like to make the motion that we increase the $250 penalty to $500.
Have a motion by Mr. Wheeler to increase the civil penalty to $500. Do I have a second on that motion? Have a second by Mr. Naylor. All in favor, please respond by saying aye. Aye. Any opposed? Motion carried. Number 11.
Next complaint is complaint number 2024-057091. This case was administratively opened following a routine inspection conducted on October 16, 2024. During the course of this routine inspection, the inspector observed the following. Respondent is the employee from the preceding complaint who had allowed their funeral director's license to expire on July 31st, 2024, and was not reinstated until September 24th, 2024. During the unlicensed period, the employee made funeral arrangements for one decedent. Respondent replied stating that the lapse in their license was, quote, due to grave oversight on their part, and they take full responsibility for not seeking the necessary clarification or advising the owners about the status of their license, end quote. Respondent stated since becoming a licensed funeral director in 2010, they had not had licensing violations, but that they have been undergoing a large amount of stress as they have become the full-time caregiver to their mother who has Alzheimer's. Respondent stated once they became aware of the renewal requirements, they worked quickly to obtain the CE credits, which were completed by August 15, 2024. Respondent said that unfortunately, even with the expedited renewal, it took several days for the submission to be processed. Respondent stated that they were under the impression that since they were working to actively submit the remaining CE hours, that their license status was under a grace period and that they did not realize they needed to pause working until the renewal was completely processed. Respondent apologized for the misunderstanding and stated they will be more diligent about meeting all requirements moving forward. So based on the above, we'd recommend a letter of warning, but also understand that to remain consistent, the board may opt to assess a civil penalty there.
So in this case, they went 2 years without any CEUs, but they got them all in 15 days. Any questions or comments? If not, I'll entertain a motion for the recommendation or an updated recommendation.
I'll make the motion that to replace a letter of warning, we go with a $250 civil penalty.
Second.
Have a motion on the floor by Mr. Wheeler, a second by Mr. Haynes, that the recommendation be a $250 civil penalty. All in favor, please respond by saying aye. Aye. Any opposed? Motion carried. Number 12.
Next complaint is complaint number 2024-057941. Complainant stated that their father passed away on September 26, 2024, and that respondent establishment made funeral arrangements with her grandmother for the decedent without their or their brother's consent. In addition to making arrangements with the non-next of kin, the complainant alleged that information on the provided death certificate is incorrect, and that respondent will not make the changes because it is against the grandmother's wishes. An office assistant with respondent replied stating that first, they did not refuse to make changes to the death certificate, but instead advised complainant as to the process and procedures for amending a death certificate, which would include an affidavit to make the desired changes. Next, the owner of respondent establishment stated they were present during the arrangement meeting where the grandmother included both grandchildren, complainant and their brother, in the arrangement process. Respondent stated during this time, all pertinent information regarding the decedent was discussed, including the details for the death certificate. Respondent stated at no time did any family member raise any concerns or objections. Respondent stated later, when complainant raised concerns about information on the death certificate, they contacted the grandmother to verify the information. Respondent stated that the grandmother confirmed that no changes were necessary because she believed the provided information was correct. Respondent provided a copy of the authorization for cremation and disposition of human remains where all three individuals, grandmother, son, daughter, signed, providing approval for cremation. Respondent in their formal response says the following, quote, Grandmother, the mother of the deceased and our primary informant, assumed responsibility for providing information for the death certificates and making arrangements. Both complainant and brother attended the arrangement meeting with grandmother, who included them as part of her decisions and invited their involvement. It is important to note that complainant arrived on her own to this meeting and actively participated, as did her brother. We were led to believe that grandmother was the primary next of kin at the time of the initial removal and arrangements. The grandmother also provided a statement which provided in part, quote, "As decedent's mother, I was the primary responsible party for making his final arrangements, which included providing the necessary information for his death certificate. During the arrangement meeting, I ensured that the decedent's children were included so that they could have a say in their father's arrangements. I included them as a way to honor their roles in the process, and at no time were they prevented from participating in the arrangements," end quote. Based on the above, it appears that although the complainant and her brother were permitted to engage in the arrangement process, to what extent is uncertain, this was done as a decision of the grandmother. Respondent's formal reply acknowledges that the grandmother was noted as the legal next of kin when stating, quote, "We were led to believe that grandmother was the primary next of kin at the time of the initial removal and arrangements," end quote. However, it does not appear that upon learning that the grandmother was not the legal next of kin, did next of kin determination shift to the decedent's children as required by law. It appears, based on the information provided, that legal authority remained with grandmother despite the emergence of two children that would take legal precedence. Luckily, it appears all parties, grandmother, brother, daughter, agreed on authorization for cremation as each party signed the document, and complainant did not object to the cremation of the decedent. However, it appears that after designating the grandmother as the legal next of kin and realizing that the decedent had two children, respondent failed to reassign next of kin determination to the children to make the arrangements and provide information on the death certificate in violation of applicable law. Based on the above, we'd recommend a $1,000 civil penalty authorized via consent order in a formal hearing if necessary.
I'll open the floor for any discussion or comments.
I make the motion we accept council's recommendation.
Have a motion on the floor by Mr. Wheeler, a second by Mr. Naylor, to accept the council's recommendation of $1,000 civil penalty. All in favor, please respond by saying aye. Aye. Any opposed? Motion carried. Number 13.
Next complaint is complaint number 2024-065741. Complainant, a family member of the decedent, alleged that the establishment the respondent works for had not been forthcoming regarding a pre-need policy involving the decedent. Complainant does not specifically specify the alleged violation of respondent funeral director. Respondent replied through counsel explaining the pre-need process for the establishment and why the information provided to complainant was accurate and not intended to be misleading. As the complainant did not specifically allege what rules and or laws respondent had violated, counsel did not directly address respondent's alleged involvement. Based on legal's review, this complaint is entirely a pre-need complaint. There is no specific allegation of violation of funeral laws or rules against respondent funeral director. Complainant opened a separate pre-need complaint against respondent establishment, and the commissioner's designee will make a determination based on the allegations contained in that complaint for the establishment's pre-need seller's registration. So based on the above, we'd recommend closure with a custom closure letter to complainant explaining the distinction between the funeral and pre-need complaint, and that the establishment complaint will be heard on the separate registration.
Questions or comments?
Motion to accept council's recommendation.
Have a motion on the floor by Mr. Wheeler to accept council's recommendation. Do I have a second?
Second.
Second by Mr. Naylor. All in favor, please respond by saying aye. Aye. Any opposed? Motion carried.
And finally, a little bit of an unusual represent. We have several cases all involving the same individual. These case numbers are 2021-037061, 2021-037081, 2021-026541, 2021-015561, 2021-015581, 2021-020121, 2022-044371, 2022-021381, 2023-029901, and finally 2023-029921. The above cited cases are all open complaints involving a former licensed funeral director. Each complaint alleges continued unlicensed activity on behalf of the respondent. Due to the extent of the recurring nature of the unlicensed activity, legal advises as the most effective and efficient manner to address these concerns is by referral to the district attorney's office in each appropriate jurisdiction. Each matter has been investigated with evidence and sworn statements collected. These materials will be provided to each district attorney along with the referral. So based on that, we'd recommend closure with each of those listed complaints referred to the district attorney in the appropriate jurisdiction.
Is it my, I guess, understanding, and for folks that may be watching, we're not going to hear it because he's not licensed or regulated by this board. So in terms, it could be a criminal activity, and that's why we're turning everything over to the district attorneys in the respective locations.
Correct. In our statutory scheme in 62-5, it does state that any violation of this part can be considered a misdemeanor offense, and that given the, I guess, consistent nature of this, and as you stated, it would most be appropriate for the district attorney to handle in their jurisdictions.
Just for me, is there a way to keep up with this down the road? I mean, I'd like to know. I mean, this is quite serious, you know, down the road if anything came up or not. I don't know if that was something we made.
No, absolutely. I know, I'm sure, I guess the level the various district attorneys may want me involved or in the loop may vary depending on the individual, but my plan at least is to not just dump the information on their desk and then say it's your problem now. If I plan on making it very clear to them that it's, as much as they want me looped in, I'm happy to do so. And I know we will, internally, the department will certainly be apprised of where these go.
Thank you, Mr. Bryant. Any other questions or comments? If not, I'll accept a motion.
I make the motion, we accept council's recommendation for closure.
Second.
Have a motion on the floor by Mr. Wheeler and a second by Mr. Naylor to accept council's recommendation for closure. All in favor, please respond by saying aye. Any opposed? Motion carried. Mr. Bryant, thank you as always for a very detailed legal report, and we appreciate the time that you put in there for us. We'll move on to the Executive Director's report, Mr. Gribble, and I'll turn that over to you, sir.
Thank you, Mr. President. Good morning, board members. First, we have our financial data for fiscal year 23-24. This was made available to the board's executive director by the Assistant Commissioner's Office for Regulatory Boards on October 8, 2024, and that data was used in compilation of this report. The beginning balance for the board on July 1, 2023 was $1,125,381. The net revenue or earnings for July 1, 2023 through June 30th, 2024 was $736,166, which made total funds available of $1,861,547. Total expenditures for July 1, 2023 through June 30th, 2024 was $763,113. And we had a reserve balance on July the 1st, 2024 of $1,098,434. And there was no core expense during fiscal year 23 and 24, which left us with a reserve balance of the $1,098,434. I will mention that probably this fiscal year there will be a core expense, but that will come this year and not on what we're reporting here. The things on the second page dive deeper into what we talked about, and that's why I wanted to send this out to you earlier. The payroll expenses, that's what we call above the line, and you can see a comparative there for 4 years. FY 2021, 21, 22, 22 and 23, and 23 and 24, and see the changes from year to year. Salaries, longevity, overtime, and employee benefits, payroll expenditures. And then going down below that, you see the various and different things, and the ones being the most expensive is travel. Now that includes travel and lodging expenses, meal expenses for board members, for for field inspectors, an investigator, and for any travel that the staff might incur. That's all in that one travel line. The other things seem pretty well self-explanatory, and then you get down to the bottom there, which is state professional services, and that's a pretty significant number. And then part of that is broken down further. Right below that is what we call cost backs. Of course, we operate within a department where we have resources from other areas. So there's administration, legal. There is no investigation cost because we have our own investigator. Now, there is an investigation section for the regulatory boards, and sometimes we do need to use them. As you can see in fiscal year 21-22 and 22 and 23, they were used on a limited basis, but this past year it was not necessary to use them, so there's no investigation cost. Field enforcement, that's inspection. Since we have our own field representatives that do our establishment inspections, there's no cost there. Centralized complaints, that's where the complaint goes. When someone first makes a complaint, they send it out to the respondent for response, they collect the response, and then they send the complaint and response over to legal. And then once the board takes their action and legal does what they do, then in the end, centralized complaints will send another communication back to the respondent and the complainant. Customer Service Center, that's where the phone calls and the emails, texts come into the Customer Service Center, and that's the amount that this board is charged for that. The $189,000 that totals all that is reflected up in the $347,000. So it's not $189,000 plus the $347. The $189 just rolls back up to the $347. So when we look at our licensing revenue, typically this board operates where the revenue is more than the expenses, or operates in the black, whichever way you want to say it, every other year. So this year that just closed was supposed to have been a year to have operated in the black. And as you will notice, we didn't. We operated in the red. Our expenses were more than our revenue of $26,947, which is so disappointing to me because we haven't done that. We haven't been operating where the expenses were more than revenue for 2 consecutive years, and probably 16, 18 years. But there are changes, a lot of changes, and we'll talk about those that reflected that. The Assistant Commissioner's Office has a person that works with us on their expenses and budgets and things. It helps us tremendously, and we were focused on this. We thought we were going to be able to come in just right under the wire, and at the last minute, we didn't do it. We thought we were going to be in a positive instead of a negative situation. The under licensing revenue, you see the $743,695. Case and complaint revenue, that is the amount of civil penalties and investigation costs that are paid to the board. Like where you assess a civil penalty or add investigation costs, that is what was paid into the board. And that was $17,641. And then the regulatory fee is the licensing fee that the department pays to finance and administration. It's through statute, so it's so much per license. So that's $25,170 that we have to pay out. So that's taken away here to show the net revenue of $736,166, which is, as I said in the email when I sent it to the board members, the sky is not falling. We're not broke. We've got $1,098,000 and $1,098,434. But at the same time, you know, we wound up with a negative balance of $27,000, which means that this board, along with other boards in the regulatory boards, will appear before the Government Ops Committee probably sometime in January, February for a self-sufficiency hearing. And that's where the Assistant Commissioner will go, and if he wants the directors to go or whatever with him, then he'll explain to the Government Ops Committee, you know, what their situation is, what's their plan, and things like that. And I know that no one is anxious to increase fees. That's, you know, as a matter of fact, this board has decreased fees twice since it's increased fees. The first time it helped people getting into the business as apprentices and decreased the fee down to $50 for the registration fee for the apprentices. And then some years after that, if you'll recall, the funeral director and embalmer renewal fees was $275. So the board decreased that to $235, which saved each person $40 if they were a single license and $80 each renewal time if they were a double license. And again, we've been able to operate every other year where we had more revenue than we did expenses until this year. So it
Mr. Gribble, would we have any idea on the, the case and complaint revenue, the 17,641, what the deficit was on that? Do we have any idea for that fiscal year how much is maybe outstanding, as far as making sure fines are collected? I think we've talked about this roughly, but how do we assure, is there a timetable that fines are?
Yes. So whenever a consent order is sent out, there's a specific time specified in that consent order that it needs to be taken care of by. What I typically do, and I know other attorneys have kind of different strategies on it, is I'll usually contact them, just kind of be, hey, where are we? Is this something you just haven't gotten around to, or do we need to go to a formal hearing? And I would say, 99% of the time we're able to settle it via consent order, and it just comes in later than it should. So I would say we monitor pretty closely. And my metrics are taking care of cases within a certain amount of time. And so a lot of that is, I would say, very closely monitored, and any that are kind of outstanding, I'm routinely following up. And it gets tricky because with a formal hearing, it can the time and funds put into it sometimes can kind of bite both ways. If we do get the complaint resolved, we reach a resolution on an issue, but sometimes depending on the nature of the complaint, we can, I guess, everyone loses a little bit, if that makes sense, to where sometimes the costs of a formal hearing can extend past what is even legally permissible as a civil penalty, since we are limited to $1,000 per day per violation. So it's also monitoring those of what makes sense of, if the only way to settle it is a formal hearing and, the board takes a little bit of a hit, then so be it, because that's what we have to do. But it is a little bit of a balancing act of which ones can we get taken care of timely, get paid, get the civil penalties paid that have been assessed, without, I guess, kind of devoting a lot of cost and time to the process of getting those taken care of.
Mr. Gribble, do you have any recommendations to the board on what you think we need to do in looking at? I mean, I'm a dual license person, so what I pay every 2 years is really not that expensive if you break it down by yearly cost. So is that something we need to look at? And the same for apprentices, we're in a day and age, things are going up. You hate to do it. We all are in business, and we hate to increase our funeral prices. But unfortunately, as the economy presses us and things going up, we have to go up in our services also. So I think that's understood if we need to do something like that. But I'd like to hear what you would recommend.
My initial thoughts is to give us a little bit more time to look at it and see how the business flows, what happens, and come back to you with a more solid recommendation. But certainly we're monitoring it and looking at it, and it may be necessary to come to you and recommend to you, a fee increase. And let me say this. Let's go back and look at that case and complaint revenue. In 2021, it was $48,935. 21-22 is $54,733. And 22 and 23 is $34,096. And then 23 and 24 is down to $17,641. We do not budget any amount for that, and we're not supposed to, because the ideal is that everybody does right and nobody gets punished and there's no money coming from that. But and I think you're doing that today already, but what I would ask you to consider is, what does it cost the board to handle a complaint? And certainly if nobody is guilty and they're not violating anything, they should not have to pay. I mean, that's part of the board's responsibility to investigate it and for legal to make a determination whether there's a violation or not. But if there is a violation, you might want to think about what you've already been thinking about today is, what does it cost to process that? And are we going to make the offender pay for their wrong, or are we going to require the good people that are doing right to supplement the cost of what they're paying? Because you have centralized complaints, you have legal, and then, staff spends time on it as well. And one thing this board has been good about this for the past several years is recovering investigation costs. The board's been good to approve that. The attorney's been good to ask for it. And it's my understanding now in formal hearings going forward that even maybe the attorney's time can be included, as well as, the administrative law judge, the investigation costs and court report and all those things, so that at least we're recovering cost. I mean, this is a year that obviously we'll have a deficit again, and we need to look at and compare, what our deficits are. I mean, just the cycle ago, when we were positive $201,000, and then this year we were down to $26,947. Another thing that caused part of that is people who are older in age, licensees that aren't practicing, have always been keeping their license. And for some reason this year, we had an unbelievable number said, okay, we've sold our business, I've retired, I've gone to work in another profession. And, I had a mortuary college buddy that he's not working funeral service in years, but he kept his license into this year. And he said, look, I'm not going to practice anymore. I'm not going to keep them. And I said, well, I understand. But when you take $470 by, 30 or 40 people, then that adds up quickly as to, as to money. That's another thing that happened. And people were late renewing. Of course, the July money doesn't help to cover us on this. It goes to the other fiscal year. So it's again, the sky's not falling, but it's something we need to be aware of. It's something we need to constantly monitor, and we will. And we'll continue to work with the person in the Assistant Commissioner's office and take their lead and guidance. And we may come back to you with some kind of recommendation or more solid.
Your feelings with the meeting with the state, do you think it'll be okay? I mean, it's hard to judge, I know, but you've probably been there before, I guess.
I haven't been before
Oh, really?
self-sufficiency hearing. I've been before
Okay.
government ops before on sunset review. My understanding is, and what we've been told, and our Assistant Commissioner Sheriff, he wants to speak to it today, the presentations made to them, they may ask questions and may make comments, but it's not where that they will immediately take any adverse action toward you. They may have several probing questions, and they could later take some kind of action through legislation or something like that, but it's not on that particular day. It's you present to them where you are, what your plan is, and then answer their questions.
So in a very hypothetical scenario, if there's a $500 fine, that's not strictly revenue that goes back into this board. That $500 is covering administration, legal, investigative costs, centralized complaints, and the customer care center? I mean, everybody gets their portion of that?
Well, the revenue goes back to the board. Let me make sure maybe I wasn't as clear as I should be. What I was just asking you to consider is, if I'm the offender and it costs the board $900
I understand.
to do what, because I was the offender, would the board members consider assessing $1,000 civil penalty instead of a $250 or $500 civil penalty? Now, if they didn't cost that much, then obviously, less than that. That was all I was asking about is, I mean, obviously, if you consider raising, and I think you probably know this from times past, but I know this board hasn't done this, if there's any fee raising or consideration of raising the fees, then there has to be a public hearing, and then we also go before Government Ops Committee to get those rules put in place too, and we have to justify as to why we're raising fees. So
Well, I think you hit the nail on the head earlier. The good folks that keep their license renewed, that try to do good and run a respectable business, shouldn't be taxed or levied for the ones who don't. Thank you, Mr. Gribble.
so no, let me go through the rest of the report if that's okay. Unless you have questions about the financial part. I mean, I know from time to time we present financial information to you, and if you remember at the November meeting, I mentioned to the board that we didn't end in a positive, we ended in a negative, and we'd have more detailed information later. Well, then December, then we had the hearing, so we didn't have a board meeting then. So this is the first time we've had to go this detailed and deep into it since then. Legislative update. The General Assembly went in session today for the 114th General Assembly. And so I'm sure there'll be some bills that may affect the funeral board. But as of now, we've not been officially contacted by either the Tennessee State Funeral Director and Morticians Association or the Tennessee Funeral Directors Association regarding their intent to pursue new legislation that would affect this board. And as always, we have an open invitation to both associations or any other interested party that would like to meet with their staff, legal counsel, legislative team prior to the introduction of legislative bills that would impact the board. The report of licenses administratively approved by the Executive Director pursuant to Board authority for the period of November 6, 2024 through January 10, 2025. You have a list of those there. Closed establishments. Here's something else that's affecting revenue to the board. As you'll notice, as you've been sitting on the board, this number is increasing. More and more establishments are closing, which obviously each one of these pays as long as they're open, they're paying a renewal fee of $575 every 2 years. So this time we have 4: Eastland Funeral Home and Cremation Service in Nashville, Gateway Funeral Home and Cremation Center in Clarksville, Lumen Cremation in Hendersonville, and Spencer Funeral Home in Spencer. The disciplinary action report for the January 14th meeting. It's a report of consent orders that have been administratively accepted and approved by the Executive Director pursuant to Board authority, and as reported on the October 2024 and November 2024 Regulatory Board disciplinary action reports. You have a list of those licensees, the location, the violation, and the civil penalty for each one of those. And then lastly is the complaint report for today. We have 64 complaints that are open. 32 of those are against funeral directors and/or embalmers, and 32 against establishments, for a total of 64 complaints. That's all I have to report to you. If you have any questions about any of that, I'll be glad to answer them.
If no questions or comments, I'll entertain a motion to accept the Executive Director's report.
Motion to approve.
Second.
Have a motion by Mr. Haynes and a second by Mr. Wheeler. All in favor, please respond by saying aye. Aye. Any opposed? Motion carried. Mr. Gribble, do we have any individuals or establishments today?
There are no individuals, but there is one establishment. The establishment is Horizon Cremations Chattanooga LLC. The intended manager is Mr. Long, and this establishment is proposed to be located at 1509 South Smith Street, Suite A, in East Ridge, Tennessee. Its ownership is a limited liability company of Horizon Cremations Chattanooga LLC, which is located in Cleveland, Tennessee. Mr. Long, if you will, please come forward. If you will, Mr. Long, introduce yourself and kind of make whatever introductory comment you want to make to the board.
Bear with me 1 second, Mr.
Hold
Long.
on, he's getting me.
Technical
No problem.
difficulties.
I'm one of those non-tech savvy guys. See, I couldn't. I might have to have Miss Bohannon.
Which folder it was in? Which folder was it? Okay.
You're the bomb. Okay.
Mr. Long, my apologies.
No problem, sir.
Go
Good
ahead.
morning, guys, ladies and gentlemen. My name is Josh Ann Long. I am third-generation funeral director and embalmer from East Tennessee. I've been in and around the funeral business most of my life. I was licensed as of December 24 as a funeral director and embalmer in the state of Tennessee.
This is a storefront location for
Yep.
cremations only?
No, sir. We'll be offering full service. Mm-hmm.
And the office will just be used for, thank y'all. I guess the office will just be used for meeting or whatever, and all embalming, cremations, services will be
Off-site.
off-site?
Yes, sir.
Mr. Gribble, as far as the application and all of the paperwork, GPL and everything there, did everything pass the state inspection?
It has been inspected and reviewed by the field rep, and I reviewed it, and it appears to all be there and not lacking anything at this time.
And this is a physical location in East Ridge, Tennessee.
Yes, sir.
All the zoning, everything looked good. May not have gotten to it yet. Will there be a casket showroom there? Will this be done online or through?
I have a monitor in the office there.
Gentlemen, do we have any questions, comments, or concerns? I know this being a storefront, that's why Mr. Gribble, does not do the approval and sends it to us for final recommendation. It appears that everything has passed inspection. I see all of the paperwork, licensing, GPL. Anything anyone else has?
Where will embalming be done?
MD Dotson and Sons, Cleveland, Tennessee.
Where?
MD Dotson and Sons, Cleveland, Tennessee.
And you're using a crematory in Georgia, is that right?
Yes. East Ridge is right on the Georgia line, so I chose to use a crematory that's just over the line there.
It's not the one that Brent Marsh was affiliated with, is it?
No, sir.
So where is your visitation and funeral ceremonies going to be held?
They can be held at the chapel of Dotson's Funeral Home or off-site at a church of
We
choice.
have a
Or
letter of that with Dotson.
Yes, sir. It is on file, and I also have one here with me.
And where would be if someone, any church facility?
Yes. Any church of choice by the family.
Will you be the embalmer when there at Dotson, or are you gonna be the license?
I will be the embalmer.
And they, I don't know how that works. Do they have to have him on, excuse me, is he have to be on staff with Dotson? Is it, since they're using their facility?
I think they would work that out
Okay.
between the two of them, I think.
The letter that we got, it says that the location will be used for all ID viewing.
Yes, sir.
At Dodson. So, but no, the visitations, excuse me, but the visitations, would they be done there as well?
Yeah, if the family so chooses to go to a funeral establishment
So
versus
the
a
letter that you
church.
have, does it state differently? Or does it state, because ID viewings and visitations are,
No, it doesn't. It doesn't state. I wasn't aware, based on the inspection and the requirements that were set in front of me for the application, that needed to be on the letter. The application request for notification of where your ID viewings will be held.
So nothing other than just arrangements would take place at this establishment, is that correct?
Correct.
Just curiosity on my part, how far is the funeral home that you're going to be using for embalming, viewing, and whatever?
They're both within 20 to 30 minutes away from that office. Yes, sir.
are we good with all ID viewings?
Yeah, I think so, since they're going to do it in an establishment that has stuff for that. And that's what he's showing that he's doing at MD Dotson and Sons Funeral Home.
Yes.
Preparation, restoration, ID viewing, all ID viewings. So there'll be no physical decedents in the storefront area.
Not at all. I do have pictures of Dotson's location if you need those. Okay.
If he hadn't been before us, that's good. Gentlemen, do you have any more questions or discussion for Mr. Long? If not,
I'll make a
I'll-
motion that we accept his application for license.
have a motion on the floor by Mr. Naylor to accept the establishment license for Horizon Cremations Chattanooga LLC. Do I have a second?
Second.
Have a second by Mr. Haynes. All in favor, please respond by saying aye. Aye. Any opposed? Motion carried. Congratulations, Ms. Long. We wish you the best, and as you've heard today, reach out.
Yeah,
Don't-
for sure.
Don't let us reach out.
Yeah, I'm glad I got to be a part of that legal portion. Thank you, guys. All right.
Going to move on to new business. I just have one, if we have any answers. For those of us that travel, when will we have maybe a definite yes on the dates in March? And from what I understand, day one would be our normal meeting day, that second Tuesday, followed by a Wednesday and a Thursday. Is that what everybody understands, and when will we know as far as rooms or what we need to do, I guess?
Yes, that's what has been discussed. Just out of an abundance of caution, I went ahead and reserved this room. We've got it reserved anyway for the usual
Meeting.
board meeting date, but I went ahead and reserved it for those 2 additional days just in case. Even if it gets moved, that's an email to change it to someone. I just didn't want someone to swoop in and get it. So I am on the lookout for a scheduling order whenever that date is officially locked in. So I believe that they will probably be in touch with you all to let you know. But as soon as I get that scheduling order, we can also separately touch base and let you all know that.
I
for sure.
appreciate that, and I know it's 2 months away, but travel and hotels, it would be nice to have that.
Yeah.
We can always cancel. I can within 48 hours, but, and do you guys know that if, for some reason, it doesn't go that week, would we still plan on having our normal board meeting that week?
I would say, generally speaking, probably so. If not, we'll have a better idea of what that looks like when it gets a little closer. So either way, we'll definitely let you know as soon as we know for certain.
I appreciate that. Anyone else have any comments, questions, under new business?
Do we expect to meet next month?
If, I was gonna kind of address that, if it looks like the continued hearing is gonna take place in March, then most likely we'll definitely need to meet next month.
Okay.
If for somehow the scheduling order puts it out to April, May, or June or something like that, which we don't think it will, then we might not meet next month. But for now, plan on meeting next month as normal, and the 3 days, 2 or 3 days.
In March.
In March.
So in March, we're looking at 10th, 11th, and 12th. Is that correct? The Monday, Tuesday, Wednesday? Or no, I'm
Yes,
off.
it would be
Sorry.
the 11th, 12th, and 13th, that Tuesday,
11th,
Wednesday,
12th,
Thursday.
and 13th.
And the 11th would have been our normal.
Okay, 11, 12.
Correct.
I'm going to go ahead and reserve hotel. I'm going to just do it when I walk back. Okay. Okay.
Any other new business? Ms. Bohannon, did we have anyone sign up for public comment?
No, sir.
Gentlemen, I appreciate your time, and I appreciate the quorum showing up. And I'll entertain my first motion.
So
To
move.
adjourn.
So move.
And second by Mr. Naylor. Board adjourned.